Robert is an attorney and conveyancer, and he focuses on property and estate agent law and is a partner with a firm called Miltons Matsemela. Now, the firm focuses almost exclusively on all aspects of property law, namely property transfer, developments, mortgage bond registration, and mortgage bond cancellation. So he has more than 20 years of experience as an attorney and is also very active in estate agent training. So today we're talking to Robert about unbundling Voetstoots and property condition reports. Good day. How are you doing, Robert?
Thank you, Michelle. Nice to be here.
Good. So, Robert, exactly what is Voetstoots?
Well, as you can probably deduct, it's an Afrikaans word, but actually comes from Old Dutch. Now, I've tried to do some research on the topic, where exactly does it come from, and aside from only being able to mostly find out what Voetstoots means, from what I could gather, it does come from an Old Dutch tradition. Now, in English, we usually say, if you don't want something anymore, if you want nothing to do with something anymore, you give it the boot.
Exactly.
You give it the boot.
Yeah.
And I think what they must have done in the olden days in Holland, I think if we have to take ourselves back 500 years into some little medieval village in the middle of Holland, you would probably find that whenever somebody bought something from somebody else, the seller would actually take his foot and literally push it away. Voetstoots.
Wow.
So I started to say foot wegstoot.
Quite aggressive.
And I think, and now, of course, you can't exactly do it to a house, push the house away. But I don't know whether they would actually stand there with their foot and push it away. But I think it's a case of, it's a traditional act where you push something with your foot and you're saying, I'm giving it the boot, I'm getting rid of it. And I think the whole idea is to say to somebody, if you're offering to buy something from me, Voetstoots, then I'm getting rid of it, I want nothing further to do with it. And I think that is where the magic lies with Voetstoots. So what Voetstoots means, and I always say when I do agent training, the simplest way to explain what Voetstoots means to a purchaser is the following. It's basically, you're saying, the buyer is saying to the seller, I'm buying the property, okay? But what I see is what I get, and what I don't see, I also get. And this is the magic of Voetstoots. So basically what the buyer is saying to the seller is, I've inspected the property, I'm happy with the way it looks, and I'm prepared to take it at risk. It means that I'm also assuming all the risk in and to the property. The point of Voetstoots is to protect the seller. And what I mean with that is, when you're buying a house Voetstoots, one has to remember it's not the seller who's offering to sell it Voetstoots. A buyer is offering to buy it Voetstoots. And I think that's very important, especially for our first-time home buyers, that they to understand when they're going out into the marketplace for the first time, they've left school, they've graduated, they now want to go and invest in property. It is so important for your purchaser to understand the importance of a Voetstoots clause, because it is a massively important aspect of a sale agreement of land, especially for second-hand transfers, for second-hand sales, because Voetstoots does not apply to a brand new property that a developer is selling, but we'll get to that just now. So when a buyer offers to buy Voetstoots, he or she is assuming the risk, because the seller is saying, all right, if you want to buy it from a Voetstoots, by all means. So I'm giving it the boot, and it's now yours. And in essence, what it means is, what you see is what you get, and what you don't see, you also get.
Sure.
Now, what that means is, if a property is purchased Voetstoots, it means that if there are any latent or hidden defects, in other words, defects that you don't see with the naked eye, and your typical example is a leaking roof.
Yes.
The seller has owned a house, and for 10 years has never had a drop coming through the ceiling, and the next winter comes, and all of a sudden there's a leaking roof. And the purchaser says, but hang on, why did you not disclose this to me? And the seller says, well, firstly, you offered to buy the house Voetstoots. You assume the risk of a hidden defect. I never promised you that the house does not have any leaks. And that is what a Voetstoots clause does. It protects the seller against any claim from a purchaser to come and look for a damages claim because of a hidden or a latent defect that gets discovered after sale. All right. So that is what a Voetstoots clause is. It's very important for the purchasers to understand that they are assuming the risk. It means that they've done a proper inspection, that they've literally opened all the taps, they've flushed the toilets to see if the toilet's flushed, they've climbed up into the ceiling to look and see whether the wooden beams are still in order, whether there's rats or mice or a damp or whatever the case is. And basically, if you want to buy property, you've got to maybe look at the title deed conditions. And if you're planning to maybe add a second, further room, or you want to add a second dwelling, or you want to go double story, or you want to maybe put up a medical practice, whatever the case might be, you've got to look at title deed conditions. You've got to inspect these things as the purchaser, because you're offering to buy it Voetstoots. And if you look at ads, nobody ever advertises a house and says, I'm selling it Voetstoots. No one says that.
No.
You're offering to buy it Voetstoots.
Yeah.
So you, the purchaser, assume the risk. You must go and check and see exactly what's going on.
Yeah.
So that is in a small nutshell what Voetstoots means.
I'm so glad that we're having this conversation, because I think there's a lot of buyers out there that has no idea about the Voetstoots or all of that.
Your first-time buyers, and I think where a lot of misconception comes in is because of the Consumer Protection Act.
Yep.
I'm pretty sure most of our listeners are that will listen to this will have heard about the Consumer Protection Act, which goes back 10 years plus. I can't even remember exactly when it commenced. What the Consumer Protection Act says is if you are purchasing something, or say, if the seller is supplying goods as defined in the Act, it means that it's got to be in a good quality. It's got to be in a good condition, pardon me. So how this works then is if you're selling a property in terms of the Consumer Protection Act, that normally applies to a developer. So the developer goes and builds a whole new block of flats or a brand new house and sells it to the consumer. Then the Consumer Protection Act will apply. Why? Because that is the supply of goods as defined in the Act. Yeah. What the Act then says is that the purchaser then has a 6-month statutory warranty. So you can't sell or buy something Voetstoots if it is a supply of goods in terms of the Consumer Protection Act. So normally you would not find a Voetstoots clause in a development sale because it has no place, because the Consumer Protection Act specifically says that you can't actually agree to anything which the Act specifically, you can't exclude something which the Act provides. So where the Act says you have a 6-month statutory warranty minimum, then you can't contract out of it. So a seller is bound. The developer has to now go and fix any latent defects that are discovered within 6 months at least after transfer or after sale. Okay. Whilst if you have a second-hand property, in other words, it's not a brand new property, you and I contract, you sell me a house or I buy a house from you, it's an ordinary second-hand property. If I offer to buy it from you Voetstoots, the Consumer Protection Act does not apply. Okay. Now, unfortunately, when the Consumer Protection Act commenced, there were some media reports which used to then say, Voetstoots is dead, Voetstoots is no longer around. It is very much alive. Okay? It's very much alive and kicking.
Even if it's not in the contract?
Even if it's not, no, that's the thing. If you don't buy Voetstoots, if you don't specifically say so, and that is why we always say to sellers of property, don't ever accept an offer unless there's a Voetstoots clause, then the buyer does have a common law warranty against defects. So, and that is why we say to sellers, don't even think of selling your property unless the purchaser is prepared to buy it Voetstoots, because it's a very powerful defense mechanism. Because the sellers, you have to imagine, many sellers, for example, don't live in their properties if it's an investment property. The guy's up in Joburg or living overseas somewhere and he sells the property, he hasn't set foot in it for 5 or 10 or 20 years or never been in the house. He doesn't really know what's wrong with it or what, you can't always rely on what the tenant tells him or maybe the rental agent has maybe not communicated with him properly. And those guys are the ones that are at risk especially. Number one. Number two, your honest seller who honestly doesn't know that suddenly there's a roof tile that's cracked. He doesn't know that come next year's rains it's going to leak like a sieve. And of course, when he sells the property, he wants to know that no one's going to come knocking on my door and complaining because of defects that I wasn't or that he wasn't aware of. And that is the point of Voetstoots. It's to make sure that the buyer cannot come knocking on the seller's door demanding compensation or a reduction in purchase price. And that is why it's such a vital component of a normal second-hand sale agreement to put that in your contract.
Great. So Robert, can a buyer still sue a seller for repair work if he buys Voetstoots, or is it an absolute defense?
No, it's not an absolute defense. And this is also where many sellers don't quite get it right. So the buyer assumes the risk, but some sellers seem to think, well, you're buying Voetstoots, which means I can just keep quiet about it.
Walk away.
And that's not quite the case. What the common law says to us is, if I buy property from you Voetstoots, it'll protect you, the seller, against any claims for latent defects after the sale's gone through, on condition that, number one, you as the seller were not aware of a latent defect at the time of sale, and it has to be a material latent defect. So we're not talking about a minor little defect. It has to be something which is so important that it would have either affected the purchaser's decision to buy in its entirety, or he would have offered a lesser amount. Okay, so it's got to be a material defect which existed at the time of sale, which could not have been determined by the purchaser upon a reasonable inspection. So in other words, it must have been hidden, it must have been latent. Either it's a carpet lying over a manhole, which, in a briar room which was built over a sewer line, which was illegal, for example, and it wasn't lifted, or whatever the case might be, or something which isn't obvious, which isn't noticeable, something that the seller knew of, okay? And the most important requirement to get around Voetstoots is for the buyer then to be able to prove not only all of those things, knowledge, the existence of the defect, that it's a material defect, that he himself couldn't have noticed it, but he also has to prove that a seller deliberately withheld it from him. He's got to prove intent. And the courts have now, for many years, all the appeal court judgments that deal with this have consistently said, if you want to get around Voetstoots, you as the buyer have to not only prove all those 4 things I've just mentioned, but above all, you almost have to prove that the seller tried to defraud you, that he intentionally or deliberately held these things away from you, and that you couldn't have noticed it yourself. And that is where it becomes extremely difficult, because now you have to take this person to court, you have to lead evidence, and you have to hope and pray that the judge believes that, based on all the circumstantial evidence, or whatever information that you can provide, or evidence that you can give, that there can be no other reasonable conclusion other than that the seller did actually intentionally and deliberately withhold this from you. So if you can't prove that, you have no hope to claim for damages. And that is how powerful a Voetstoots clause is. It's a massively powerful defense in the hands of the seller.
So what is a property condition report?
Right. Now, the property condition reports also caused a bit of chaos for us conveyancers.
Yes.
Let's quickly look at it this way. The Estate Agency Affairs Board, as it was known before it became the Property Practitioner Regulatory Authority from the 1st of Feb this year, they created this document called the Property Condition Report about 10 or 15 years ago. I can't remember. It was quite a while ago. And the purpose of that document back then and today still is to actually protect the estate agent. It's to afford the seller the opportunity to disclose any latent defects that they might be aware of, material latent defects, to the agent. And the agent then attaches this to any template or draft sale agreement, which he then presents to the purchaser, which means that the purchaser will do an inspection. He will also have an opportunity to look at the property condition report. And this property condition report is normally phrased, it used to always be phrased along the lines of that the seller says that to the best of his knowledge and belief, and please note this is where it's important, that to the best of his knowledge and belief, he can answer the following questions as yes or no or maybe, whatever the case might be. And it was an optional document. It wasn't compulsory back then. So before the 1st of Feb 2022, the Estate Agency Affairs Board used to suggest to the agents, guys, please use this document. It's there for your protection. Why? Because if the buyer comes back later and says, but you, the agent, didn't tell me about this and that, the agent can say, well, I'm sorry, this document is what the seller gave me and this is all I know about the property.
Exactly.
Many purchasers suffer under the belief that an agent's job includes going and looking for the mistake. Not the mistakes, going and looking for the defects.
Yeah, exactly.
Please, that is not the case. Okay, an agent's job is to take a mandate from a seller, market the property and find a willing and able buyer. That's it. What the Code of Conduct says that regulates estate agents is that an agent has to disclose everything that the agent knows about the property or should reasonably know and which might be of importance to a buyer. That's a very general concept. That could mean a million things. It could exclude a million things. And because of this, and I think that's where this document comes from, is that the Estate Agency Affairs Board said back then, you know what, guys, here's a document. Use this. Get the seller to complete this. It gives you a pretty good overall picture of what the condition of the property is like. And where the seller says, look, I don't know. I can't answer the question. I can't tell you if there's a leak. I can't tell you if this and that. Then he says so. Then the agent says to the buyer, right, here's a document that the seller has given me. It's now up to you to inspect the property properly and to decide from here on out what offer you want to make and what conditions you want to impose on the sale agreement. So that was the purpose of the document back then. And then from the 1st of Feb, when the new Property Practitioner Act commenced, it replaced the Estate Agency Affairs Act. So the Estate Agency Affairs Board no longer exists. We now have the Property Practitioners Regulatory Authority. So estate agents, property practitioners, pretty much the same thing. Except property practitioners also include a whole other sphere of personalities, but we don't need to go into that now. And the only difference between then and now is that the legislation has made it compulsory. And the Act says to agents that you may not or you should not take a property to market. You shouldn't market a property if your seller has not given you a property condition report. Now, it's mandatory in the sense that if an agent does take a mandate on a property and takes it to market and the seller does not give him or her a property condition report, then what happens is, what that simply means is that the law then presumes that you as the agent did not disclose any defects to the buyer. So it puts you at risk. And it takes us back to the original intent of the document, which is to protect estate agents. So now the law is, if you want to sell a property without a property condition report, go for it, be my guest. But what the law is saying, it's like saying to a child, don't touch a hot stove. But if you want to touch the hot stove, you're going to burn your fingers and then you must just live with the consequence. And that's basically what this is. So it doesn't invalidate a sale agreement if there isn't a property condition report. It doesn't invalidate the mandate. It just means that the agent is exposing him or herself to the potential of being sued for negligence or for misrepresentation because he or she can't now prove what defects were disclosed to the purchaser. So that is why the property condition report now is such a vital document, because it actually serves to protect the agent, number one, but it also then allows the seller the opportunity of disclosing any defects that he or she might know or might not know of. And then it's for the purchaser to make an informed decision. What's also important about the property condition report is that it specifically has a clause which says that this doesn't form a warranty or a guarantee or a promise of any kind. The seller is simply saying that to the best of his knowledge and belief, as far as I know, A, B, C, D, E. Okay, that's the first thing. The other thing that the property condition report also now provides is that it gives the buyer advice. It says to the purchaser, if you want to get a home building inspector to first look at the property, you might want to do so.
Okay.
So if you're buying, especially if you're buying a house that's a real fix-me-upper, and you think to yourself, I'm going to just give it a quick lick of paint and I'm going to replace a few tiles, rather get somebody with a bit of handyman experience to go and then do a proper analysis to see what exactly is actually required. But that's the point of this property condition report, is it protects the agent, but it also gives the buyer a bit of advice on maybe getting a home inspection and also being able to make a proper and a more informed decision. Okay, so that's the point of a property condition report. Now, how does it tie in with Voetstoots? Well, a property condition report doesn't replace Voetstoots. Like I said, it's there to protect.
Because I was going to ask you now.
Right. It's there to protect the agent. It's there to also inform the buyer and to give the seller an opportunity to make some more disclosures. What some sellers think is that they've now signed off this property condition report, they've got a Voetstoots clause, so they're completely safe. Once again, the question is whether you as the seller misrepresented. Did you lie when you completed this form? And if you did, now you must remember, I buy a house from you, I offered to buy it Voetstoots. And I offered to buy it Voetstoots because you said to me as the buyer, there's nothing wrong with the property.
Yes.
I said, all the answers on this questionnaire is no, 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 no. I don't know anything wrong, nothing wrong with the property. Why would I climb into the roof? Why would I get a home inspector?
You've got no reason to do that.
In other words, what sellers, the mistake that they make now again is they forget, if I buy a house Voetstoots, it's possibly because of the answers you gave me in the condition report. So the condition report comes first. Because of that, I make an offer to buy Voetstoots. If I cannot prove that you lied in this document, Voetstoots is not going to protect you. It's not going to help you as a seller at all, because you misrepresented to me. You lied to me, or you gave me fake information. Again, it's all about evidence. You'll have to try and
prove it.
Try and find out. You'll have to try and prove it, and that's where it becomes exceptionally difficult for the purchasers. And that's where it becomes very difficult. So the property condition report, it's now compulsory for agents to have this document when they're taking a mandate before they take the property to market. And if they don't, they could get into trouble. They could face personal liability because of that. It doesn't, like I said just now, it doesn't invalidate a mandate. It doesn't invalidate the sale. It just means that you as agent are taking a chance. Now, the one question that I have to also answer here is what happens if you have a seller who doesn't want to sign a property condition report because he's an investment owner and he's never set foot in the property, so he can't really answer the questions honestly, or you have executors of deceased estates, or you have curators of people that have been declared incapable of managing their affairs. The curator now becomes the seller, or the executor of a deceased estate actually factually becomes the seller. Now you're sitting with somebody who works for a bank in a trust department, who's executor of an estate here in Cape Town. He hasn't a cooking clue what the house looks like or what condition it's in, etc. And those are your typical people that say, look, I'm not prepared to sign this document. I'm not going to commit to anything, okay? And what we then do there is we tell the agents in that case just to make a note on that form. It must still be attached to the sale agreement, but then the seller says, I cannot complete this form because I don't know. So you, the purchaser, are prepared to buy this property as it is. In other words, don't come knocking on my door. And what we also then put in a little disclaimer there is to protect the agent, where the agent then also says in the document, look, I've made you no promises, I've made no disclosures, you, the buyer, are buying completely at your own risk. And that is the difference between a property condition report and Voetstoots. It doesn't really have an effect. Voetstoots is still very much alive and kicking despite a property condition report.
Okay, so Voetstoots covers the seller and the PCR, then this agent. What covers the buyer?
I'm glad you asked the question. That's a very good question. Under South African law, in fact, I'm super glad you've asked this question, because what many purchasers don't get is that they pay the cost for transfer. Any sale agreement will always say, unless it's a purchase agreement from a developer, because most development sales are cost inclusive, the developer pays the transfer costs. Your typical standard OTP, or offer to purchase, says that the purchaser must pay all the costs for transfer. Right, so they will pay transfer duty, they will pay our disbursements, they will pay the deeds office fee, they'll pay our transfer fee, etc., etc. If we have to get a homeowners association consent or a levy figures from the body corporate, all those costs involved there are for the purchaser's account. What the purchasers now think is that because they're paying us, that we represent them. And that's where they make the biggest mistake. Unfortunately, in South Africa, the law is that the seller nominates the transferring attorney. The seller says, I'm going to appoint Miltons, Matsemela, I want them to do my transfer. And why? Because it's the seller's property. Until the seller has been dispossessed or disowned of his property and has been registered on the name of the buyer, he is supposed to stay in control of the transfer process. So when we act in a transfer, our primary obligation lies to the seller, because the seller is the one who appointed us. So even though the purchaser is paying our costs, We have I might want to call it a secondary obligation to the purchaser. Obviously, we have to look after the purchaser's interests. I've got to make sure that the transfer happens in accordance with the terms and conditions in the OTP. If the seller has to do certain repair work, I've got to first check, have you done the repair work? If there's a tenant and you're supposed to give vacant occupation, I have to make sure, is the tenant out before I transfer the property, obviously to protect the buyer. But if a dispute arises between the buyer and the seller about defects,
which happens all the time.
And it happens a lot. And especially with the rains we had this year, the storms we had a couple of weeks ago, I mean, the phone didn't stop ringing with leaks and water running through the roof and down the walls, and it was a mess. The only thing the purchaser can do is report the defects to us, which is traditionally what happens. They'll go to the agent will come to us and say, Robert, this guy's listed a whole bunch of defects that they've discovered now after transfer or after occupation. What we then do is we pass it on to the seller. And all I do is I have a rhyme which I say to the seller, I say, right, the law is this. Did you know about this defect? Did it exist at the time of sale? Did you know about it? Was it not discoverable by the purchaser upon a reasonable inspection? Mm-hmm. And did you deliberately withhold it from the buyer? And if you did not do any of these things, well, then you don't have to pay for it. And then I have to say, you know the facts, I don't know the facts. Only you, the seller, can tell me what the situation is. And if the seller denies liability, I have to then go back to the purchaser and say, look, I'm very sorry, my seller is not prepared to admit liability. You will now have to get yourself your own attorney to assist you going forward. And that's literally where our intervention ends. We'll try and mediate, we'll try and find a solution. We'll try and get, if there are, put it this way, we'll often rely also on the agents, because the agents have to then tell us what was the condition of the property. Yeah. I mean, we weren't there. We were only doing the transfer. We were not there at the time of signing. We weren't there at the time of viewing. So we don't know what the property condition was like. And sometimes with the agent's input, we could possibly find out that the seller isn't maybe being entirely honest. I mean, I've got some examples of typical scenarios where it was quite abundantly clear that the seller was lying. Sure. But those are few and far between. Yeah. 99% of the time, when I say to a purchaser, look, if you want to sue the seller who has now denied liability, you're going to have to prove not only that the seller knew about this, but that you, the buyer, couldn't yourself have picked up on this defect. But above all, you have to prove that the seller deliberately lied to you. You've got to prove fraud. A state of mind, which is very difficult, and you can only do that through circumstantial evidence, really. The evidence has to really be profound for a judge or a court to believe that the seller actually deliberately tried to withhold something from you as the buyer. So the protection that the buyer has, to answer your question, it's a long answer, sorry about that. Most, especially first-time buyers, would be very well advised to go not only to work through the agent, but also maybe to appoint their own attorney. If you're prepared to go and spend R1 million, R2 million, R5 million on a home. Yeah. When I have to just take it to the next example, people that go and buy a pair of shoes or a pair of jeans will walk from one shop to the next in a shopping mall. They spend all morning looking for the perfect trousers or the perfect shoes.
That's me.
But when they go look at a house, half an hour, 45 minutes, ooh, I love this house, let's put an offer in.
That's so true.
They're prepared to spend millions within half an hour,
sure,
but they'll spend a half a day to spend 600 rand. Now, so what protection does a buyer have? Well, if you're going to spend millions of rands on a property, spend 2,000 or 3,000 rand with an attorney and get proper advice. Let them have a look at the OTP, the offer to purchase. Let them also explain the ins and the outs. There's so many clauses in the contract that you have to look at. Most contracts are anything between 5 and 10 pages. And they always say in law, read the fine print. Read the fine print. Don't just sign, and initial. Make sure, if you want to be protected as a purchaser, consider also going and getting an attorney involved from the get-go. Because like I said earlier on, unfortunately, the law in South Africa is that if I'm nominated by the seller, he's my primary client and he's the one that I've got to protect primarily. Of course, I have to also look after the purchaser as far as I can, but the moment there's a conflict, I have to step back and say to the purchaser, sorry, you have to now get your own attorney. I cannot represent, I can't ride two horses. Yeah. Is basically why we have the situation.
So what advice do you have for first-time buyers?
Generally, read the contract carefully. Read the contract very carefully. Get an attorney if you can. Don't rush into it. Yeah. Don't rush into it, and do a thorough inspection. If you're going to look at the property, take your time. Climb on the roof. Every property I've bought, people think I'm mad. I always say, get me a ladder, please. I've literally climbed on every roof of every house I've ever bought. I've literally done that. I've actually climbed into ceilings. I do that because I want to see for myself what's going on. Yeah. I'd open taps, I open cupboard doors. Unfortunately, people might get offended if I'm going to open their bedroom cupboards. But you know what? Well, if you want me to buy this house for 2 or 3 million rand, I'm going to open your cupboard doors.
Exactly.
So hide your underwear if it's going to be offensive to you. But it's my money at the end of the day. Exactly. Flush the toilets. Check that everything works. Don't expect the seller to always have made disclosure, because like I said just now, your seller might not have lived in the house for the past 10 years.
Yeah.
And that property condition report very clearly says it is not a guarantee. It's not a promise of anything. It's a document that the seller completes to the best of his knowledge and belief. So he's not saying it is a fact, he's saying as far as I'm aware, A, B, and C. And that is where there's a massive difference. And purchasers need to be aware of this. Especially, like I said just now, your first-time buyers.
Sure.
Those your inexperienced buyers. Those are the ones that are mostly at risk, and they're the ones that need more protection than anybody else.
Yeah. Robert, thank you so much. That was really so insightful. And I think you've taught a few of us a few lessons today, what we should do when we purchase a property. Thank you.
Great stuff. Thank you.
Miltons understands the importance of transferring properties and registering bonds promptly, efficiently, and cost effectively. If you would like to find out more or make use of their services, feel free to visit miltons.law.za or get in touch with them directly by sending an email to info@miltons.law.za.